Welcome to Hull on Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada. From the offices of Hull and Toronto, here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 172 of our podcast on Tuesday, July 14th, 2009.
Hi, Suzana. How are you?
Well, thank you, Ian. How are you?
You don't really care. You're just asking to be nice.
That's how it goes.
Okay. It's for those that saw our last podcast. I was humiliated by not being interested in Suzana and how she was. I'm over it, though. Okay, so let's keep talking, because this is exciting stuff. I love the cottage transfer and how we can manage it, and I love flogging our brochure, which by this point will have had tons of hits, because it is a great brochure, and I don't say that because I wrote it. You wrote it, and I can say it, and she won't admit it. But all right, so we're talking about transferring the cottage property, and in summary we talked about really looking at it from the emotional and family dynamic, tying in the management through tax issues. Then we've worked through all of the other issues in our series here now, and where we're at now is talking about how best to transfer on death. Mm-hmm. And we left at the joint tenancy thing. And the problem with the joint tenancy arguments and problems, issues that arise, is that that's like 25 podcasts worth of talking. So we don't want to spend 25 on this topic, but we do need to kind of close the loop. And we finished our last podcast talking about it being a hybrid, because you have to do the act of joint tenancy, putting the cottage joint with right of survivorship, so on death it passes to the other joint tenant during your lifetime. So it's an act during lifetime, and it is an act that is transparent and registered on title. We've talked about some of the problems that a ne'er-do-well co-tenant could do, and that is sever the joint tenancy. What we didn't, and we just touched on briefly though, is that there is a strong argument, and while we don't have the tax advice, there are some people that would maybe say that there was a deemed disposition at the creation of the joint tenancy. Mm-hmm. And so any growth, there's a deemed disposition, so there may be tax owing then, and any growth may be attributable to the joint tenants, the two joint tenants.
Right.
So those are some tax problems, some control issues that we talked about, someone just swiping the other half from you. But we live in a world that we see only bad behavior, but good behavior, and in the right situation, again, we're about putting options on the table to our clients. In the right situation, the joint tenancy is a fantastic tool.
That's right.
So, we don't want to be too naysaying about it.
Just because we see the bad side doesn't mean that there isn't a good side to it.
That's right.
And that's a really good point here.
Absolutely. And I met with a client the other day who has utmost faith in their family behaving. And we go through the options, we say to them this could go badly, and they just look at you like you're smoking something,
yeah.
right?
How could you say that?
That's right. And so, but that's good. That's good, because most of the time they're right.
Yes.
Okay, so gifts on death. We talked about joint tenancy. Let's talk about ones that really matter on death, and that is, of course, putting the gift of the will, of the cottage, in your will. Mm-hmm. And what does that impact, and what are some of the things that occur in that scenario?
And that really, Ian, is what we see most often. What people will do is they'll leave someone the cottage property. They may leave it to all their children, they may leave it to some of their children, they may leave different options for that gift, whether it's an outright gift, it could possibly be a purchase, the right of first refusal of some sort that's included in the will. Again, there's a lot of flexibility in terms of what could be in that will and how that ultimately gets transferred to the beneficiaries.
Terrific. And that's where you've got an opportunity to do some really creative estate planning. Mm-hmm. And there's a reason why it's actually pretty good to leave things in your will, right? Because during lifetime, when you give things away, you lose control and you lose access and so on. When you die, you don't care. And if you plan it well and you communicate your plan well, there is nothing more powerful than a good will with a good estate plan backed up by full communication with your family to pass on what is a powder keg of an asset. Mm-hmm. So, as excited as I am about a couple podcasts ago about gifting and sale, I just think that's a cool way of really approaching the issue while you're alive. Mm-hmm. If you don't want to approach it while you're alive, and you do the sort of things that we talk about, and that is fundamental communication, excellent advice, you can creatively pass on the family cottage in ways that would blow your mind. Like the flexibility, the things that I have seen, the way they've set up funding mechanisms for the capital expenses and looking after the property, usage methods and so on. There's all sorts of cool things that you can do to really affect the plan. So as excited as I am about during lifetime, gifting during the will, if done well, is the most powerful way to do it.
That's right.
in my view anyway.
Okay.
All right, so now that we've got it gifted, the other thing, and we talked about this in the previous podcast, is that what are we going to do if we want to set it up in a more, a little bit of a, we'll call it ruling from the grave approach.
Yes.
All right, and what are we getting at there?
Probably a testamentary trust.
Absolutely, as opposed to an inter vivos trust.
Or a lifetime trust, one that you would create during your lifetime. And so again, a lot of flexibility that we can put into a will, but create a little bit of more control than an outright transfer by the will would have done otherwise.
It works great in situations where you got minor children getting it,
yes,
for sure, or you got kids in their 20s getting it, and you don't want them having full control and access of the property to mismanage.
That's right.
It gives you great opportunity to put in some wonderful clauses about usage and funding mechanisms to pay for the expenses. It gives you all sorts of tax advantages. You know, again, 101 tax, not that we know anything about it, is you tax during a lifetime in an inter vivos lifetime trust, it's higher than you tax in a testamentary trust. Right. So there are tax savings that are embedded in it. Tax savings which may not seem like a lot, but might be enough to pay for the property taxes. Right? Like, you know, in that sense. So there's some really creative tools that we can do, and we go through it in our brochure with some, you know, some detail. The last part of our the gifting plan is, of course, just an outright gift. The option of picking a beneficiary, giving it outright. Maybe attaching the tax liability to that gift or not. You know, and that is a difficult decision, but properly communicated. Just deciding, look, Betty is the only one who wants the cottage. She should get it, and she should make capital gains tax on it. I don't know, but let's address that in the will. So the outright gifting mechanism is available, and we talked about the will where we got lots of flexibility, but we can also, in a will, outright gift. And I like to say to clients, look, put a comma and deal with how the tax is going to be paid. Whether you put it in the will or not is a drafting issue, but deal with your family on that, because that tax can be such a burden. And if there is a $200,000 life insurance policy there that is supposed to be funding the tax liability, and you're outright gifting it to one of the kids as opposed to the other, look at the ripple effect.
Yeah.
And
the biggest example of that, and one that we see quite often, is a parent may think that they're leaving half of their estate to each child. The cottage is worth, let's say, $500,000, and their estate is worth $500,000. Their liquid estate,
yes,
the cash or what have you. And at the end of the day, that $500,000 property may have a tax liability of $150,000.
Yes.
And where would that come from? But for that comma that you were saying, and pay the tax, that would come out of the other individual's residue of the estate.
Correct.
And so perhaps an unexpected, and probably an unexpected result in those circumstances. So it underscores not only the importance of talking to your family, but also getting advice, and good advice in advance, so that you know what's going to happen at the end of the day, right?
Yeah. We tell our clients, look at the big picture, where you're going to land, and don't look at the mini battles along the way. Look at where we're trying to land. And if you're staying on plan, so to speak, to where you're going to land, then you've achieved a result. And so often you get stuck in these little mini steps along the way. Well, I love the idea of a trust, and I love this, or I'm going to give this property to charity, but only on the death of my children, and all those sorts of things. Make sure we keep an eye on the ball where we're landing. That's right. Okay, well, we're just about wrapping this up, and it's good because our next podcast will be, the summer will be almost half over by that point. And we'll hopefully be wrapping up our summer series on the cottage transfer and talking about, with some particularity, what are some of the ways to create agreements that work for everyone. So it's not just a will that works for everyone, not just a trust that works for everyone, but some agreements, contracts, enforceable, compelling things like that. So we'll talk through that in our next podcast, and look forward to it, and I hope you stay well.
Thank you very much. Ian.
Thank you.
You have been listening to Hull on Estate and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.